Can I just say something about Andrea?
Tyler Robinson's next court hearing is scheduled for Friday, and it's going to be on the defense's motion to remove the cameras from the courtroom. I wanted to make this video to give you a little bit of an introduction to the defense's motion, what they're asking, and what that request is based on, and then give you some of my thoughts about this motion itself, what it's identifying as a problem, the likelihood of success, and just set your expectations a little bit for what I think we're going to see at the hearing tomorrow. So we'll start by looking at the motion itself. You will see, of course, this is a very lengthy motion, 258 pages with exhibits attached to it. So we are not going to read through this entire motion in this video. You are more than welcome to read the motion if you would like to do so. There is a link on my Substack to the legal documents that I collect in this particular case. So you are welcome to follow that link and read the document on your own time, should you be inclined to do so. But we are going to take a look at the broad outline of the argument that they're presenting and talk about some of what this argument is based on. So the bottom line here, given the particular circumstances of this capital case, where the amount of prejudicial electronic media pretrial publicity is already extremely high and is likely to continue, and where the electronic media has already violated the court's decorum order and directly caused further prejudice, continuing to allow live streaming of all proceedings would infringe Mr. Robinson's fundamental right to a fair and reliable trial and sentencing hearing by an impartial jury, as guaranteed by the 6th, 8th, and 14th Amendments to the United States Constitution and their Utah constitutional counterparts. Bottom line, this is a high-profile case. From the moment Charlie Kirk was shot and killed, it was kind of inevitable that any prosecution of a suspect was going to get a lot of attention. The fact that Charlie Kirk himself is a high-profile individual, is a political figure, and the fact that he was murdered publicly on video, where lots of people witnessed what happened, pretty much guaranteed that if a suspect were captured and submitted to the court process, that there was going to be a lot of interest in that court process. So this is not new. This is not something that has only come about with the internet age. For pretty much as long as there have been public courtrooms, there has been public interest in what happens in those courtrooms, particularly in cases that have particular interest because they involve famous people or because they involve particularly egregious crimes. So what the defense is pointing out here is that there is an environment, a media environment of commentary on this case that the defense believes is prejudicial to Mr. Robinson's right to get a fair trial, and that the live streaming of the court proceedings exacerbates or contributes to the media ecosystem that is creating so much of this prejudicial coverage. So the court has a constitutional duty to take strong measures to ensure that Mr. Robinson's right to a fair trial by an impartial jury is protected from prejudicial electronic pretrial publicity. This point is getting at the heart of the conflict that you run into when you have cameras in the courtroom or just any kind of public interest in a high-profile case, which is the conflict between the public's First Amendment right to know what its government is doing, which applies to our ability to observe criminal court prosecutions, with the defendant's right to a fair and impartial jury to decide his guilt or innocence. And so if those rights can't be reconciled, then something has to give. The defense is arguing that those rights cannot be reconciled, and therefore what needs to give is the access that the media is receiving to the courtroom to be able to live stream the court hearings. B, the prejudicial pretrial electronic media coverage in this case clearly meets the threshold standard set forth in Sheppard for invoking this court's affirmative constitutional duty to take protective measures to protect Mr. Robinson's due process rights by prohibiting further electronic media live streaming. This is, of course, broken into several subparts, but this is referring to a well-known U.S. Supreme Court case, Sheppard v. Maxwell, which we are going to take a look at momentarily. The fact that the state and its agents released extremely prejudicial information and opinions to the media in violation of applicable law and standards weighs in favor of granting this motion. The defense is arguing that many of the statements that were made by prosecutors, law enforcement, the governor, other high-profile individuals involved in the investigation made statements that are prejudicial and should not have been allowed under the rules that are applicable to public statements about criminal proceedings. The state contests this characterization. So that is a potentially disputed issue. One, did these public figures break the rules when they spoke about the case? And two, if they did, what's the appropriate recourse for that? The defense is arguing taking the cameras out of the courtroom is a potential remedy. D, the traditional means of controlling prejudicial pretrial publicity are not available or have not been or will not be effective in this case. This is a criticism of the kind of default fix for pretrial publicity that we've heard come from Judge Graff. He's stated it in this case. It's in multiple case decisions and so forth, which is that the remedy for pretrial publicity is in the jury selection process. It simply means you need to take different steps to properly screen the jurors that are coming before the court and potentially going to be asked to decide this particular case in order to rule out the possibility of biased jurors ending up serving. This is, part 3. The termination or restriction of further electronic media live streaming and photographic coverage of any proceedings is also warranted under Rule 4-401.01. This is Utah's rule that the court adopted that creates a strong presumption in favor of having cameras in the courtroom. This rule was adopted after considerable study was done about pretrial publicity and the effects of cameras in courtrooms. Are they a good thing? Are they a bad thing? And as a result of that study, the Utah courts determined that, in their view, cameras in the courtroom are generally a good thing, that transparency overcomes potential problems that you might have from increased attention and commentary and so forth. And therefore, the Utah rules create a presumption that if somebody asks to have a camera in a court proceeding, that request should be granted absent proof of some significant overriding interest that can't be protected in any other way. There are, as we see here, a few exhibits attached. Court order declaration of Dr. Ruva, which we will also look at momentarily, a couple redacted items, and then the order in the state of Idaho versus Koberger. We'll just go ahead and jump down to this real quickly, just because yet again, we are seeing a lot of Koberger crossing over into this case. This is the order that Judge signed when he found that Court TV was repeatedly violating the court's rules on how the cameras were to be operated in the case. Specifically, they're not supposed to zoom in on and focus on Brian Koberger's face. They just couldn't not do that. And so Judge signed an order that took away the pool camera. But what he did do is he allowed the proceedings to continue to be live streamed by using the court's virtual court system, the web court system that they have, which frankly, pretty much every courtroom in the country post-COVID now has, because they all had to get very comfortable with doing court remotely. And so most of them have now systems for Zoom Court or WebEx or just whatever platform that they use, where people can appear remotely and other people can be present in the courtroom. All of that can be integrated and maintained by different video feeds. So that feed remained available for the public to be able to view through the live stream under Judge's order. But he did remove the media pool camera based on the repeated violations of the decorum order. So that is the motion. Let me get back up to the top so I don't lose my place here. So the first thing that I wanted to share with you after we took a look at this motion is the case that the defense is relying on so heavily, and that is this Sheppard versus Maxwell case. So Sheppard versus Maxwell, as you can see, from 1966. This is well before the internet era. This is in the early days of cameras starting to be in courtroom and court proceedings being on TV. We're going to read through primarily the introduction that explains kind of the facts and the context here so that you can see the circumstances that were present in this case that the Supreme Court looked at and said, that doesn't look like a fair trial to me. The judge fell short in his responsibility, so they need to do this one over. Marilyn Sheppard, petitioner's pregnant wife, was bludgeoned to death in the upstairs bedroom of their Lakeshore home in Bay Village, Ohio, a suburb of Cleveland. On the day of the tragedy, July 4th, 1954, Sheppard pieced together for several local officials the following story. He and his wife had entertained neighborhood friends, the Aherns, on the previous evening at their home. After dinner, they watched television in the living room. Sheppard became drowsy and dozed off to sleep on a couch. Later, Marilyn partially awoke him, saying that she was going to bed. The next thing he remembered was hearing his wife cry out in the early morning hours. He hurried upstairs, and in the dim light from the hall, saw a form standing next to his wife's bed. As he struggled with the form, he was struck on the back of the neck and rendered unconscious. On regaining his senses, he found himself on the floor next to his wife's bed. He rose, looked at her, took her pulse, and felt that she was gone. He then went to his son's room and found him unmolested. Hearing a noise, he hurried downstairs. He saw a form running out the door and pursued it to the lakeshore. He grappled with it on the beach and again lost consciousness. Upon his recovery, he was lying face down with the lower portion of his body in the water. He returned to his home, checked the pulse on his wife's neck, and determined or thought that she was gone. He then went downstairs and called a neighbor, Mayor Hook of Bay Village. The mayor and his wife came over at once, found Sheppard slumped in an easy chair downstairs, and asked, "What happened?" Sheppard replied, "I don't know, but somebody ought to try to do something for Marilyn." Mrs. Hook immediately went up to the bedroom. The mayor told Sheppard, "Get a hold of yourself. Can you tell me what happened?" Sheppard then related the above outlined events. After Mrs. Hook discovered the body, the mayor called the local police, Dr. Richard Sheppard, petitioner's brother, and the Aherns. The local police were the first to arrive. They in turn notified the coroner and the Cleveland police. Richard Sheppard then arrived, determined that Marilyn was dead, examined his brother's injuries, and removed him to the nearby clinic operated by the Sheppard family. When the coroner, the Cleveland police, and other officials arrived, the house and surrounding area were thoroughly searched. The rooms of the house were photographed, and many persons, including the Hooks and the Aherns, were interrogated. The Sheppard home and premises were taken into protective custody and remained so until after the trial. So this is our outline of the crime and the explanation that was given by the primary witness, the husband of the decedent. And we learned that the husband of the decedent is connected. He's got a brother who is the coroner, the medical doctor, not the coroner, but a local doctor. They run a local medical clinic, and they are friendly enough with the neighbor to call the mayor, and have them show up and get a response and so forth. From the outset, officials focused suspicion on Sheppard. After a search of the house and premises on the morning of the tragedy, Dr. Gerber, the coroner, is reported, and it is undenied, to have told his men, "Well, it is evident the doctor did this, so let's go get the confession out of him." He proceeded to interrogate and examine Sheppard while the latter was under sedation in his hospital room. On the same occasion, the coroner was given the clothes Sheppard wore at the time of the tragedy, together with the personal items in them. Later that afternoon, Chief Eaton and 2 Cleveland police officers interrogated Sheppard at some length, confronting him with evidence and demanding explanations. Asked by Officer Schottky to take a lie detector test, Sheppard said he would if it were reliable. That's quite a big if. Schottky replied that it was infallible. What a lie. And you might as well tell us all about it now. At the end of the interrogation, Schottky told Sheppard, "I think you killed your wife." Still later in the same afternoon, a physician sent by the coroner was permitted to make a detailed examination of Sheppard. Until the coroner's inquest on July 22nd, at which time he was subpoenaed, Sheppard made himself available for frequent and extended questioning without the presence of an attorney. On July 7th, the day of Marilyn Sheppard's funeral, a newspaper story appeared in which Assistant County Attorney Mann, later the chief prosecutor of Sheppard, sharply criticized the refusal of the Sheppard family to permit his immediate questioning. From there on, headline stories repeatedly stressed Sheppard's lack of cooperation with the police and other officials. Under the headline, "Testify now in death, Bay doctor is ordered," one story described a visit by Coroner Gerber and 4 police officers to the hospital on July 8th. When Sheppard insisted that his lawyer be present, the coroner wrote out a subpoena and served it on him. Sheppard then agreed to submit to questioning without counsel, and the subpoena was torn up. The officers questioned him for several hours. On July 9th, Sheppard, at the request of the coroner, reenacted the tragedy at his home before the coroner, police and officers, and a group of newsmen who apparently were invited by the coroner. So we're starting to see, just in this paragraph here, a little bit of a melding between the prosecution and the press. We have a county attorney who is making statements to the press that are rather problematic in that they kind of overlook the defendant's absolute constitutional right not to cooperate with the prosecution. And the fact that in a jury trial, the jury will be specifically instructed that they cannot draw any adverse inference if a defendant chooses not to testify, not to cooperate with police, and so forth. So it suggests an inference by an attorney who should know better that the jury would never be permitted to draw a trial. Then we also now have one of the investigators, the coroner, apparently bringing the media in to attend portions of the investigation. This is Certainly not typical and generally not a good idea. The home was locked so that Sheppard was obliged to wait outside until the coroner arrived. Sheppard's performance was reported in detail by the news media along with photographs. The newspapers also played up Sheppard's refusal to take a lie detector test and the protective ring thrown up by his family. Front page newspaper headlines announced on the same day that Dr. Balks at lie test retells story. A column opposite that story contained an exclusive interview with Sheppard headlined, "Loved my wife, she loved," I think this is supposed to be me, Sheppard tells news reporter. The next day, another headline story disclosed that Sheppard had again late yesterday refused to take a lie detector test and quoted an assistant county attorney as saying that at the end of a 9-hour questioning of Dr. Sheppard, I felt he was now ruling a test out completely. But subsequent newspaper articles reported that the coroner was still pushing Sheppard for a lie detector test. More stories appeared when Sheppard would not allow authorities to inject him with truth serum. No shit, you don't want to be injected full of some substance by police so that they can ask you questions that they intend to use the answers against you when you have a constitutional right not to do that? Yeah. No kidding. Of course he didn't. Oh my Lord. You think don't talk to the police is routine advice. Don't allow the police to shoot you up with a substance before they ask you questions is an even easier one to say. Yeah, don't be doing that. Absolutely no obligation to do that, and nothing but negative potential to come from submitting to something like that. On the 20th, the editorial artillery opened fire with a front page charge that somebody is getting away with murder. The editorial attributed the ineptness of the investigation to friendships, relationships, hired lawyers, a husband who ought to have been subjected instantly to the same third degree to which any other person under similar circumstances is subjected. The following day, July 21st, another one-page editorial was headed, "Why no inquest? Do it now, Dr. Gerber." The coroner called an inquest the same day and subpoenaed Sheppard. It was staged the next day in a school gymnasium. The coroner presided with the county prosecutor as his advisor and 2 detectives as bailiffs. In the front of the room was a long table occupied by reporters, television and radio personnel, and broadcasting equipment. The hearing was broadcast with live microphones placed at the coroner's seat and the witness stand. A swarm of reporters and photographers attended. Sheppard was brought into the room by police who searched him in full view of several hundred spectators. Sheppard's counsel were present during the 3-day inquest, but were not permitted to participate. When Sheppard's chief counsel attempted to place some documents in the record, he was forcibly ejected from the room by the coroner, who received cheers, hugs, and kisses from ladies in the audience. Sheppard was questioned for 5.5 hours about his actions on the night of the murder, his married life, and a love affair with Susan Hayes. At the end of the hearing, the coroner announced that he could order Sheppard held for the grand jury, but did not do so. Now we're starting to see the process itself begin to become distorted for the benefit of the media spectacle. So not merely allowing the media to be present and observe, but conducting the proceedings in a way to satisfy the public opinion that is beginning to develop that this is a case where guilt should be a foregone conclusion. This individual should be charged, but he is getting special treatment by virtue of his connections. And so we're not allowing legal representation in order to appease the masses who have preformed opinions about the case. And all of this is taking place on television. Throughout this period, the newspapers emphasized evidence that tended to incriminate Sheppard and pointed out discrepancies in his statements to authorities. At the same time, Sheppard made many public statements to the press and wrote feature articles asserting his innocence. During the inquest on July 26, a headline in large type stated, "Kerr, captain of the Cleveland police, urges Sheppard's arrest." In the story, Detective MacArthur disclosed that scientific tests at the Sheppard home have definitely established that the killer washed off a trail of blood from the murder bedroom to the downstairs section, a circumstance casting doubt on Sheppard's accounts of the murder. No such evidence was produced at trial. The newspapers also delved into Sheppard's personal life. Articles stressed his extramarital love affairs as a motive for the crime. The newspapers portrayed Sheppard as a Lothario, fully explored his relationship with Susan Hayes, and named a number of other women who were allegedly involved with him. The testimony at trial never showed that Sheppard had any illicit relationships besides the one with Susan Hayes. On July 28th, an editorial entitled, "Why Don't Police Quiz Top Suspect?" demanded that Sheppard be taken to police headquarters. It described him in the following language: "Now proved under oath to be a liar, still free to go about his business, shielded by his family, protected by a smart lawyer who has made monkeys of the police and authorities, carrying a gun part of the time, left free to do whatever he pleases." A front page editorial on July 30th asked, "Why isn't Sam Sheppard in jail?" It was later titled, "Quit Stalling, Bring Him In." After calling Sheppard the most unusual murder suspect ever seen around these parts, the article said that except for some superficial questioning during coroner Sam Gerber's inquest, he has been scot-free of any official grilling. It asserted that he was surrounded by an iron curtain of protection and concealment. That night at 10 o'clock, Sheppard was arrested at his father's home on a charge of murder. He was taken to the Bay Village City Hall, where hundreds of people, newscasters, photographers, and reporters were awaiting his arrival. He was immediately arraigned, having been denied a temporary delay to secure the presence of counsel, and bound over to the grand jury. The publicity then grew in intensity until his indictment on August 17th. Typical of the coverage during this period is a front page interview entitled, "Dr. Sam, I wish there was something I could get off my chest, but there isn't." Unfavorable publicity included such items as a cartoon of the body of a sphinx with Sheppard's head and the legend below, "I will do everything in my power to help solve this terrible murder." Sounds like, it won't rest until we find the true murderers of Nicole Brown Simpson and Ron Goldman. Headlines announced inter alia that doctor evidence is ready for jury. Corrigan tactics stall quizzing. Sheppard gay set is revealed by Hook. Blood is found in garage. New murder evidence is found, police claim. Dr. Sam faces quiz at jail on Marilyn's fear of him. On August 18th, an article appeared under the headline, "Dr. Sam Writes His Own Story." And reproduced across the entire front page was a portion of the typed statement signed by Sheppard. "I am not guilty of the murder of my wife, Marilyn. How could I, who have been trained to help people and devoted my life to saving life, commit such a terrible and revolting crime?" Oh, the "it's impossible" defense. We do not detail the coverage further. There are 5 volumes filled with similar clippings from each of the 3 Cleveland newspapers covering the period from the murder until Sheppard's conviction in December of 1954. The record includes no excerpts from newscasts on radio and television, but since space was reserved in the courtroom for these media, we assume that their coverage was equally large. So this is the background of kind of what was going on in the media that was stirring up commentary about the case and generating public interest. And the kind of bottom line here is that this is a case where the public is seeing somebody who they believe is getting disparate treatment for a very serious crime, and that is because of his prestige, his power, his connections, and so forth. And so because of that, they are taking a particular interest in whether the law enforcement and the prosecutors are acting appropriately in the decisions that they're making concerning the investigation. These are all squarely within the First Amendment's right to monitor what our government is doing, talk about it, and have opinions about what it is that we see. But where this is extending a bit beyond just normal opinion and assessment and so forth, is the way that the factual dispute is starting to play itself out in the public forum rather than in the courtroom. So that information about evidence and investigation and so forth is being presented to the media, not waiting for the court process to vet some of those facts. So that is a factual distinction from the situation that we're dealing with in Tyler Robinson's case, where the initial court documents, the statement of probable cause and so forth, provide some basic information that supports why the suspicion against Tyler Robinson led to him being arrested and charged with the crime in the first place. But the continuation of the investigation is not being shared with the press, and that is because there is a gag order in place that, unlike this situation where apparently police would just go in and the coroner would go and tell the press what they think and new things that are happening, whether true or not. In the current case, they're prohibited from doing that. It will be contempt of court if they were to do that. And so this is why we have a very limited insight into how the investigation has proceeded since the time that Tyler Robinson was arrested and the original probable cause that they had to justify that arrest. So now we move on to the trial itself. With this background, the case came on for trial 2 weeks before the November general election, at which the chief prosecutor was a candidate for common pleas judge, and the trial judge, Judge Blythen, was a candidate to succeed himself. So we have an environment where political people are looking for political favor. That's potentially important. 25 days before the case was set, 75 veneermen were called as prospective jurors. All 3 Cleveland newspapers published the names and addresses of the veneermen. As a consequence, anonymous letters and telephone calls, as well as calls from friends regarding the impending prosecution, were received by all of the prospective jurors. The selection of the jury began on October 18th, 1954. Publishing the names of the jury panel before they are selected and before the trial is concluded and so forth is very much a potential problem, and one that just has the potential to kind of independently justify throwing out these jurors and bringing in a new panel, regardless of any of the other circumstances that are present in this case. That is a huge bad judgment call. It is contrary to current standards for publication by news organizations that tend to follow standards. And at this point, courts routinely will not release this information about the juror identities until the case is already concluded. The courtroom in which the trial was held was measured 26 by 48 feet. A long temporary table was set up inside the bar in back of the single counsel table. So this is beyond the bar. The bar is a visual representation of where the parties, the officers of the court, are allowed to be and where the public is allowed to be. The media are not officers of the court. They are simply representatives of the public. They enjoy the same rights as any other member of the public when it comes to attending court and having access to court documents and things like that. But we see there's a special accommodation being made for the media to sit in the area where the officers of the court are normally the only ones who get to be there, which the public is not going to be allowed to do. It ran the width of the courtroom parallel to the bar railing with one end less than 3 feet from the jury box. Approximately 20 representatives of newspapers and wire services were assigned seats at this table by the court. So newspapers, journalists are sitting right behind the counsel tables, right next to the jury in the courtroom. Beyond the bar railing, there were 4 rows of benches. These seats were likewise assigned by the court for the entire trial. The first row was occupied by representatives of television and radio stations. The second and third rows by reporters from out-of-town newspapers and magazines. One side of the last row, which accommodated 14 people, was assigned to Sheppard's family and the other to Marilyn's. The public was permitted to fill vacancies in this row on special passes only. So they gave special access to the press and excluded the public as a result. This is not consistent with the First Amendment, recognizing that the media may be able to represent the public's interests in certain respects when it comes to access to court proceedings and things like that. But they are not themselves different or better than the public. They enjoy no right of access beyond what the public themselves enjoy. This order that essentially bans the public to the benefit of the media is contrary to those First Amendment principles. Representatives of the news media also used all the rooms on the courtroom floor, including the room where cases were ordinarily called and assigned for trial. Private telephone lines and telegraphic equipment were installed in these rooms so that reports from the trial could be speeded to the papers. Station WSRS was permitted to set up broadcasting facilities on the 3rd floor of the courthouse next to the jury room, where the jury rested during recesses in the trial and deliberated. Newscasts were made from this room throughout the trial and while the jury reached its verdict. On the sidewalk and steps in front of the courthouse, television and newsreel cameras were occasionally used to take motion pictures of the participants in the trial, including the jury and the judge. Indeed, one television broadcast carried a staged interview of the judge as he entered the courthouse. In the corridors outside the courtroom, there was a host of photographers and television personnel with flash cameras, portable lights, and motion picture cameras. This group photographed the prospective jurors during selection of the jury. After the trial opened, the witnesses, counsel, and jurors were photographed and televised whenever they entered or left the courtroom. Sheppard was brought to the courtroom about 10 minutes before each session began. He was surrounded by reporters and extensively photographed for the newspapers and television. A rule of court prohibited picture taking in the courtroom during the actual sessions of the court, but no restraints were put on photographers during recesses, which were taken once each morning and afternoon with a longer period for lunch. All of these arrangements with the news media and their massive coverage of the trial continued during the entire 9 weeks of the trial. The courtroom remained crowded to capacity with representatives of news media. Their movement in and out of the courtroom often caused so much confusion that despite the loudspeaker system installed in the courtroom, it was difficult for the witnesses and counsel to be heard. Furthermore, the reporters clustered within the bar of the small courtroom made confidential talk among Sheppard and his counsel almost impossible during the proceedings. They frequently had to leave the courtroom to obtain privacy. And many times when counsel wished to raise a point with the judge out of the hearing of the jury, it was necessary to move to the judge's chambers. Even then, news media representatives so packed the judge's anteroom that counsel could hardly return from the chambers to the courtroom. The reporters vied with each other to find out what counsel and the judge had discussed, and often these matters appeared in newspapers accessible to the jury. The daily record of the proceedings was made available to the newspapers, and the testimony of each witness was printed verbatim in the local editions, along with objections of counsel and rulings by the judge. Pictures of Sheppard, the judge, counsel, pertinent witnesses, and the jury often accompanied the daily news. and newspaper and television accounts. At times, the newspapers published photographs of exhibits introduced at the trial, and the rooms of Sheppard's house were featured along with relevant testimony. The jurors themselves were constantly exposed to the news media. Every juror, except one, testified at voir dire to reading about the case in the Cleveland papers or to having heard broadcasts about it. 7 of the 12 jurors who rendered the verdict had one or more Cleveland papers delivered in their home. The remaining jurors were not interrogated on the point, nor were there questions as to radios or television sets in the jurors' homes, but we must assume that most of them owned such conveniences. As the selection of the jury progressed, individual pictures of prospective members appeared daily. During the trial, pictures of the jury appeared over 40 times in the Cleveland papers alone. The court permitted photographers to take pictures of the jury in the box and individual pictures of the members in the jury room. One newspaper ran pictures of the jurors at the Sheppard home when they went there to view the scene of the murder. Another paper featured the home life of an alternate juror. The day before the verdict was rendered, while the jurors were at lunch and sequestered by 2 bailiffs, the jury was separated into 2 groups to pose for photographs which appeared in the newspapers. So I hope it is, becoming clear that this is a rather extraordinary set of affairs. This is more than just the media is in the courtroom reporting on the courtroom. This is the media is interfering with the process itself. They can't have confidential conversations during the course of the trial. They sometimes can't hear the trial. The jury is going to become extremely self-conscious because they're being scrutinized, they're being publicized, they are being made into little mini celebrities before they have even made their decision about the case. This is a disaster in far more ways than just the media is providing information about what is happening inside this courtroom to interested viewers. We now reach the conduct of the trial. While the intense publicity continued unabated, it is sufficient to relate only the more flagrant episodes. On October 9th, 1954, 9 days before the case went to trial, an editorial in one of the newspapers criticized defense counsel's random poll of people on the streets as to their opinion of Sheppard's guilt or innocence in an effort to use the resulting statistics to show the necessity for change of venue. The article said the survey smacks of jury tampering, called on defense counsel to drop it, and stated that the Bar Association should do something about it. It characterized the poll as non-judicial, non-legal, and nonsense. The article was called to the attention of the court, but no action was taken. On the second day of voir dire examination, a debate was staged and broadcast live over WHK radio. The participants, newspaper reporters, accused Sheppard's counsel of throwing roadblocks in the way of the prosecution and asserted that Sheppard conceded his guilt by hiring a prominent criminal defense lawyer. Sheppard's counsel objected to this broadcast and requested a continuance, but the judge denied the motion. When counsel asked the court to give some protection from such events, the judge replied that WHK doesn't have much coverage and that, after all, we are not trying this case by radio or in newspapers or any other means. We confine ourselves seriously to it in this courtroom and do the very best we can. While the jury was being selected, a 2-inch headline asked, "But who will speak for Marilyn?" The front page story spoke of the perfect face of the accused. Study that face as long as you want. Never will you get from it a hint of what might be the answer. The 2 brothers of the accused were described as prosperous, poised. His 2 sisters-in-law, smart, chic, well-groomed. His elderly father, courtly, reserved, a perfect type for the patriarch of a staunch clan. The author then noted Marilyn Sheppard was still off stage and that she was an only child whose mother died when she was very young and whose father had no interest in the case. But the author, through quotes from Detective Chief James MacArthur, assured readers that the prosecution's exhibits would speak for Marilyn. Her story, MacArthur stated, will come into this courtroom through our witnesses. The article ends, then you realize how what and who is missing from the perfect setting will be supplied, how the big case justice will be done. Justice to Sam Sheppard and to Marilyn Sheppard. As has been mentioned, the jury viewed the scene of the murder on the first day of the trial. Hundreds of reporters, cameramen, and onlookers were there, and one representative of the news media was permitted to accompany the jury while it inspected the Sheppard home. The time of the jury's visit was revealed so far in advance that one of the newspapers was able to rent a helicopter and fly over the house, taking pictures of the jurors on their tour. On November 19th, a Cleveland police officer gave testimony that tended to contradict details in the written statement Sheppard made to the Cleveland police. 2 days later, in a broadcast heard over station WHK in Cleveland, Robert Considine likened Sheppard to a perjurer and compared the episode to Alger Hiss's confrontation with Whittaker Chambers. Though defense counsel asked the judge to question the jury to ascertain how many heard the broadcast, the judge refused to do so. The judge also overruled the motion for continuance based on the same grounds, saying, well, I don't know, we can't stop people in any event listening to it. It is a matter of free speech, and the court can't control everybody. We are not going to harass the jury every morning. It is getting to the point where if we do it every morning, we are suspecting the jury. I have confidence in this jury. So the judge is abdicating his responsibility to ensure that the jury is not being improperly exposed to external influences from outside of the courtroom. On November 24th, a story appeared under an 8-column headline. Sam called a Jekyll Hyde by Marilyn cousin to testify. It related that Marilyn had recently told friends that Sheppard was a Dr. Jekyll and Mr. Hyde character. No such testimony was ever produced at the trial. The story went on to announce the prosecution has a bombshell witness on tap who will testify to Dr. Sam's display of fiery temper, countering the defense claim that the defendant is a gently physician with an even disposition. Defense counsel made motions for change of venue, continuance, and mistrial, but they were denied. No action was taken by the court. When the trial was in its 7th week, Walter Winchell broadcast over WXEL television and WJW radio that Carol Beasley, who was under arrest in New York City for robbery, had stated that, as Sheppard's mistress, she had borne him a child. The defense asked that the jury be queried on the broadcast. 2 jurors admitted in open court that they had heard it. The judge asked each, would that have any effect upon your judgment? Both replied no. This was accepted by the judge as sufficient. He merely asked the jury to pay no attention whatever to that type of scavenging. Let's confine ourselves to this courtroom, if you please. In answer to the motion for mistrial, the judge said, well, even so, Mr. Corrigan, how are you ever going to prevent those things in any event? I don't justify them at all. I think it is outrageous, but in a sense, it is outrageous even if there were no trial here. The trial has nothing to do with it in the court's mind as far as its outrage is concerned. But, Mr. Corrigan, I don't know what effect it had on the mind of any of these jurors, and I can't find out unless inquiry is made. The court, how would you ever, in any jury, avoid that kind of a thing? How could you avoid requiring the jury not to look at media about the case? How could you ever do that? Perhaps by requiring them to vow that they will do that and then evaluating whether they commit misconduct, violate the court's order or not. But the court has simply thrown up its hands, taken no responsibility for even basic tasks like ensuring the integrity of the jury throughout the trial. On December 9th, while Sheppard was on the witness stand, he testified that he had been mistreated by Cleveland detectives after his arrest. Although he was not at the trial, Captain Kerr of the Homicide Bureau issued a press statement denying Sheppard's allegations, which appeared under the headline, "Barefaced Liar," Kerr says of Sam. Captain Kerr never appeared as a witness at the trial. I mean, you want to talk about now trying the case in the court of public opinion. The law enforcement witness not subjecting himself to the oath and the penalty of perjury and the cross-examination that comes with being a witness in court, but giving your version of events nevertheless to the press, who swallows it and reports it uncritically. After the case was submitted to the jury, it was sequestered for its deliberations, which took 5 days and 4 nights. After the verdict, defense counsel ascertained that the jurors had been allowed to make telephone calls to their homes every day while they were sequestered at the hotel. Although the telephones had been removed from the jurors' rooms, the jurors were permitted to use the phone in the bailiff's rooms. The calls were placed by the jurors themselves. No record was kept of the jurors who made calls, the telephone numbers, or the parties called. The bailiff sat in the room where they could only hear the jurors' end of the conversation. The court had not instructed the bailiffs to prevent such calls, so they really weren't sequestered at all. By subsequent motion, defense counsel urged that this ground alone warranted a new trial, but the motion was overruled and no evidence was taken on the question. Pretty extreme circumstances here. Exceeds significantly just the press being interested in the case, the press covering the case, the press even having opinions about the case, and having a lot to say about it. Getting into direct interference with the court process itself in the presentation of evidence, the ability to defend, the impartiality and separateness of the jury. All of these things being extremely distorted throughout this process. So now let's look at the reason why the U.S. Supreme Court looked at all these facts and said, yeah, this is not going to be okay. This is going to be a problem. We can't rely on this trial as having been fair. So we first notice that there is a premise of open courts. Justice cannot survive behind walls of silence. We have to be able to talk about what happens in the courtrooms. The press is conventionally who does this on our behalf. They are our representatives who go out and get the information and then disseminate it to the rest of us who can't be present. But the court points out that legal trials are not like an election to be won through the use of the meeting hall, the radio, and the newspaper. This is a little bit of a different situation than your conventional political advocacy or political opinions, because the jury's decision about guilt and innocence is really not a political issue. Now, it may reflect political issues such as how cases are investigated, who, asks questions and who doesn't, the process itself, criticism of the process itself, and whether it, produces a fair result or not. A lot of political implications in a trial, but the actual decision on guilt and innocence is a decision that is based on the evidence presented for the jury to make. And so it's not the type of thing that you really want to be subject to public opinion. If public opinion determines the outcome of criminal trials, then you may as well just not have a trial and simply have the mob. The mob will be able to express the public opinion through the power of its ability to get the outcome it wants. So the whole reason why we have trials at all is to prevent that type of thing from happening, from preventing public opinion to be the guiding light on guilt or innocence, and instead requiring impartial people to consider evidence and decide what they think happened based on that. So there are some basic requirements of fundamental fairness in trials that are necessary for them to serve their function, including the jury's verdict be based on evidence received in open court, not from outside sources, and that being prejudiced by news accounts to information that was not admitted can be a big problem. You don't just take a juror's word for it that oh, I can put this, I read this, but I can push it out of my mind. The court has a responsibility to objectively determine what the potential impacts of exposure to that information could do. The theory of our system is that the conclusions to be reached in a case will be induced only by evidence and argument in open court and not by any outside influence, whether of private talk or public print. So a lot of this concern has to do with the press reach to the jury, not simply the presence of the media in the courtroom and their interest in the case. So another issue here, the burden of showing essential unfairness as a demonstrable reality need not be undertaken when television has exposed the community repeatedly and in depth to the spectacle of the accused personally confessing in detail to the crimes with which he was later to be charged. So, when the public has already been advised through the newspapers about what the evidence in the case is going to consist of, they are naturally going to form judgments based upon that. They're going to form opinions about what they think the outcome of the trial is and should be based on that information. So this is an issue that in terms of the standards that are applicable today and in Tyler Robinson's court, the gag order, as well as the ethical rules that apply to the prosecuting attorneys, as well as the defense attorneys in this case, limit their ability to make these kinds of statements. So interviews from the judge, the county attorney, the detectives, and so forth about materials that are not being presented to the jury in the course of the trial. This is not going to happen in Tyler Robinson's case, at least not without a serious risk of contempt of court and sanctions. So where the court in Sheppard did nothing to try to control any of that, Judge Graff has already taken that particular protective step by preventing the parties from sharing extrajudicial information about the case, meaning anything that isn't already coming out through the court documents or the court hearings. So they refer to a last case where they set aside a conviction because they have to presume the process is so bad, you have to presume that it is inherently lacking in due process. And in this case, they believe that the totality of the circumstances warrant a similar approach. In this case, Sheppard was not granted a change of venue to a locale away from where the publicity originated, nor was his jury sequestered. These are the two main ways that exist to protect against the potential taint of a jury by the media. You want jurors that don't know much about the case. And so one possibility, you just draw the jury from a different jurisdiction where the publicity hasn't been so intense and so pervasive. And you prevent them from, or prohibit them from accessing media coverage during their service as jurors on the case so that they can't be influenced by outside information and commentary and so forth. The Estes jury saw none of the television broadcasts from the courtroom. On the contrary, the Sheppard jurors were subjected to newspaper, radio, and television coverage of the trial. While not taking part in the proceedings, they were allowed to go their separate ways outside of the courtroom without adequate directions not to read or listen to anything concerning the case. The judge's admonitions at the beginning of the trial are representative. People, those of us who watch the criminal trials, see these admonishments all the time. They are routinely now given, like at the beginning of the case, at every recess. Caution the jury not to read, watch TV, look on the internet, research the case, etc. Here's what the judge in this case said. I would suggest to you and caution you that you do not read any newspapers during the progress of this trial, that you do not listen to radio comments, nor watch or listen to television comments insofar as this case is concerned. You will feel very much better as the trial proceeds. I am sure that we shall all feel very much better if we do not indulge in any newspaper reading or listening to any comments whatever about the matter while the case is in progress. After it is all over, you can read it to your heart's content. Trust me, guys, you'll feel better. You'll feel better. This is not this is not an order. This is not an admonishment. This is not even particularly discouraging. This is a suggestion that the jurors are going to be able to weigh against their own perception of, am I going to have more confidence in my understanding of the case if I ignore everything that the media is saying, or if I pay attention to it? And guys, I gotta say, this is I think this is a normal experience and expectation for people to have, because they know that what gets presented as evidence in court isn't always all of the evidence that there is. That evidence is excluded from the courtroom for a whole variety of reasons. And so therefore, I can certainly see how a juror who understands that basic aspect of the trial process might think to themselves, actually, Judge, I'll have a better idea of the case and feel better about my decision if I know what I'm not hearing just as much as if I hear what I am. At intervals during the trial, the judge simply repeated his suggestions and requests that the jurors not expose themselves to comment upon the case. Moreover, the jurors were thrust into the role of celebrities by the judge's failure to insulate them from reporters and photographers. Pictures of the jurors, the fact that the anonymous letters had been received, all of these things should have been red flags, but were not. So this related case, Estes, not related, but the case, the analogous one that they're using, not even this big of a deal in terms of the publicity that it's got. The Sheppard case was significantly more. All these facts, the politicized environment, etc. Well, we cannot say that Sheppard was denied due process by the judge's refusal to take precautions against the influence of pretrial publicity alone. The trial court's later rulings must be considered against the setting in which the trial was held. So, not controlling the pretrial publicity is not the problem. There are First Amendment implications to the pretrial publicity. But the problem is that publicity creates a context that the trial is taking place in that can jeopardize the fairness of the trial. And that's why the pretrial publicity matters, because it speaks to the risk to the trial process. In light of this background, we believe that the arrangements made by the judge with the news media caused Sheppard to be deprived of that judicial serenity and calm to which he was entitled. The fact is that bedlam reigned at the courthouse during the trial, and newsmen took over practically the entire courtroom, hounding most of the participants in the trial, especially Sheppard. The Supreme Court is as disturbed as I am about bringing the press beyond the bar where just the officers of the court are supposed to be. The erection of a press table for reporters inside the bar is unprecedented. The bar of the court is reserved for counsel, providing them a safe place in which to keep papers and exhibits and to confer privately with client and co-counsel. It is designed to protect the witness and the jury from any distractions, intrusions, or influences, and to permit bench discussions of the judge's rulings away from the hearing of the public and the jury. Having assigned almost all of the available seats in the courtroom to the news media, the judge lost his ability to supervise that environment. The movement of the reporters in and out of the courtroom caused frequent confusion and disruption of the trial, and the record reveals constant commotion within the bar. Moreover, the judge gave the throng of newsmen gathered in the corridors of the courthouse absolute free rein. Participants in the trial, including the jury, were forced to run a gauntlet of reporters and photographers each time they entered or left the courtroom. The total lack of consideration for the privacy of the jury was demonstrated by the assignment to a broadcasting station of space next to the jury room, on the floor above the courtroom, as well as the fact that jurors were allowed to make telephone calls during their 5-day deliberation. Again, focus here primarily on the jury and the process. Not the opinions, not the statements about the case, or even the reporting the false information. These are simply background that sheds light on why it was so problematic for the media to control the environment, the physical environment in the courtroom while this trial was happening. So the publicity itself, now we turn to, no question about the nature of it. Murder and mystery, society, sex, and suspense were combined in this case in such a manner as to intrigue and captivate the public fancy to a degree perhaps unparalleled in recent annals. Throughout the pre-indictment investigation, the subsequent legal skirmishes, and the 9-week trial, circulation-conscious editors catered to the insatiable interest of the American public in the bizarre. In this atmosphere of a Roman holiday for the news media, Sam Sheppard stood trial for his life. All the way back in 1966. Okay. And even in this case, not the first time this has happened. Guys, the media is acting like grifters. Grifters have now made their appearance. Haven't been explicitly called that, but that's what the court is saying. The court is saying that they're catering to the public appetite for controversy and excitement and so forth. Indeed, every court that has considered this case, save the court that tried it, has deplored the manner in which the news media inflamed and prejudiced the public. There's a footnote here that just contains some of these comments about criticism of the trial process. Much of the material printed or broadcast during the trial was never heard from the witness stand, such as the charges that Sheppard had purposely impeded the murder investigation, must be guilty since he had hired a prominent criminal lawyer, was a perjurer, had sexual relations with numerous women, slain wife had characterized him as Jekyll Hyde, that he was a barefaced liar because of his testimony as to police treatment, and finally that a woman convict claimed Sheppard to be the father of her illegitimate child. A lot of mis and disinformation in the case being published by the media. In this respect, the Kohberger case is potentially a much better analog to Sheppard versus Maxwell than what we're seeing in the Tyler Robinson case. That was one of the fundamental problems with the Bryan Kohberger prosecution was media reporting sourced to quote unquote anonymous law enforcement sources that would provide information, or anonymous sources close to the investigation that would provide information that repeatedly turned out to be untrue. Whether we're talking about Bryan Kohberger stalked the victims, whether we're talking about, there have been all kinds of crazy stories that were reported. He had the victims' ID cards, in a box in his car. This was a misreading of one of the search warrants. All kinds of misinformation and false information produced to the media in the course of that case. Not really seeing that so much in Tyler Robinson's case, at least from the prosecution side. We're not seeing a lot of this anonymous law enforcement sourcing and things like that. Nor is there doubt that this deluge of publicity reached at least some of the jury. So it's not just the fact that this was bad media, this is bad journalism in the first place. It's also the fact that this journalism reached the jury. That's what made it so potentially problematic. On the only occasion that the jury was queried, 2 juries admitted in open court to hearing the highly inflammatory charge that a prison inmate claimed Sheppard as the father of her illegitimate child. Despite the extent and nature of the publicity to which the jury was exposed during trial, the judge refused defense counsel's other requests that the jurors be asked whether they had read or heard specific prejudicial comments about the case, including the incidents we have previously summarized. In these circumstances, we can assume that some of this material reached members of the jury. The court's fundamental error is compounded by the holding that it lacked the power to control the publicity about the trial. What can the court do in this context? Let's find out. From the very inception of the proceedings, the judge announced that neither he nor anyone else could restrict prejudicial news accounts, and he reiterated this view on numerous occasions. Since he viewed the news media as his target, the judge never considered other means that are often utilized to reduce the appearance of prejudicial material and to protect the jury from outside influence. We conclude that these procedures would have been sufficient to guarantee Sheppard a fair trial, and so do not consider what sanctions might be available against a recalcitrant press, nor the charges of bias now made against the state trial judge. Gag orders, gags against the media. You can't report this, you can't say that. Presumptively unconstitutional under the First Amendment. Extremely difficult to justify under the law. And so what this court is saying here is that just because the ability to issue a gag order against the press is extremely limited, that does not mean that there aren't other things you can do to prevent the effects of that publicity from tainting the process. So first, the carnival atmosphere itself could have easily been avoided, since the courtroom and the courthouse premises are subject to the control of the court. Courts have enormous discretion over the conduct of their courtroom and what happens inside, to set rules of behavior and conduct and so forth. They are under no obligation to allow the press to set the rules about what coverage is going to look like. Secondly, the court should have insulated the witnesses. All of the newspapers and radio stations apparently interviewed prospective witnesses at will, and in many cases disclosed their testimony. Although the witnesses were barred from the courtroom during the trial, the full verbatim testimony was available to them in the press. This completely nullified the judge's imposition of the rule. Sequestering the witnesses during the trial is extremely common. You're excluded from the courtroom while the other witnesses are testifying so that you don't either deliberately or even inadvertently alter your testimony to accommodate new information that is coming out from other people. As far as pretrial, you can discourage it. Can you gag it? Now we're getting a little bit closer into the gray area of what's allowed and what is not allowed, because gagging, you're talking about a gag order, and witnesses don't lose their First Amendment rights just by virtue of becoming witnesses in a court case. So shutting up the witnesses pretrial might not itself be an option. At the best, it's in a bit of a gray area. But if nothing else, you can sequester the witnesses during trial so that they aren't simply reading the same press reports as everybody else and potentially altering their testimony accordingly. Third, the court should have made some effort to control the release of leads, information, and gossip to the press by police officers, witnesses, and the counsel for both sides. Well, isn't that exactly what we have in Tyler Robinson's case? We have a gag order that prohibits the members of the respective teams, which is defined to include the law enforcement officers that work for the prosecution, as well as expert witnesses and so forth for both sides. They're subject to the gag. They're not allowed to provide new information to the press beyond what is coming out in court documents and court hearings. It does not explicitly apply to the witnesses, but it requires the prosecuting attorney and the defense team to advise their witnesses that it really would be better if they didn't take reasonable steps to prevent the witnesses from prejudicing the proceeding. The parties aren't the keeper of the witnesses. They can't force them to do anything, but they can certainly share with them that, you may jeopardize the ability to get a fair trial here, and a fair trial here jeopardizes the potential to have an outcome that is going to stick and that everybody can rely on. So really would probably be better if you voluntarily took it upon yourself to not engage in that type of communication. So some effort has in fact been taken by the judge in Tyler Robinson's case. So defense counsel immediately brought to the court's attention the tremendous amount of publicity in the Cleveland press that misrepresented entirely the testimony in the case. Under such circumstances, the judge should have at least warned the newspapers to check the accuracy of their accounts. And it is obvious that the judge should have further sought to alleviate this problem by imposing control over the statements made to the news media by counsel, witnesses, and especially the coroner and the police officers. Prosecution repeatedly made evidence available to the news media, which was never offered in the trial. Much of the evidence disseminated in this fashion was clearly inadmissible. The exclusion of such evidence in court is rendered meaningless when news media make it available to the public. So again, just reiterating, you can point out to the press. We saw this in Koberger when they were litigating the motion to change venue, emphasizing many of these press reports, they're false. They're false. And it would be, great if the press would confine themselves to the verifiable record of what goes on in a court proceeding. But that's inconsistent with the incentives that journalists have to scoop and get exclusives and develop new information that's surprising and so forth. Everybody wants a Perry Mason moment, and lots of people apparently think they're going to be the ones that come up with that. Reality in court is often and typically quite a bit less interesting than that. More specifically, the trial court might well have proscribed extrajudicial statements by any lawyer, party, witness, or court official which divulged prejudicial matters, such as the refusal of Sheppard to submit to interrogation or take any lie detector tests, any statement made by Sheppard to officials, the identity of prospective witnesses or their probable testimony, any belief in guilt or innocence, or like statements concerning the merits of the case. These types of statements are now incorporated into the ethical rules that apply to lawyers in the case and the statements that they're able to make to the press about their own cases. The judge in Tyler Robinson's case has applied those rules broadly to the entire defense team, meaning including the experts and the law enforcement witnesses and so forth. And it has encouraged both the prosecution and the state. It's required them to take reasonable steps to communicate to their lay witnesses that it would be better if these types of things aren't mentioned by you or discussed by you in the press. So once again, this step has kind of already been taken in Tyler Robinson's case. From the cases coming here, we note that unfair and prejudicial news comment on pending trials has become increasingly prevalent. Due process requires that the accused receive a trial by an impartial jury free from outside influence. Given the pervasiveness of modern communications and the difficulty of effacing prejudicial publicity from the minds of the jurors, the trial courts must take strong measures to ensure that the balance is never weighed against the accused. And appellate tribunals have the duty to make an independent evaluation of the circumstances. Of course, there is nothing that proscribes the press from reporting events that transpire in the courtroom. But where there is a reasonable likelihood that prejudicial news prior to a trial will prevent a fair trial, the judge should continue the case until the threat abates or transfer it to another county not so permeated with publicity. In addition, sequestration of the jury was something the judge should have raised sua sponte with counsel. If publicity during the proceedings threatens the fairness of the trial, a new trial should be ordered. But we must remember that reversals are but palliatives. The cure lies in those remedial measures that will prevent prejudice at its inception. The courts must take such steps by rule and regulation that will protect their processes from prejudicial outside interferences. Neither prosecutors, counsel for the defense, the accused, witnesses, court staff, nor enforcement officers coming under the jurisdiction of the court should be permitted to frustrate its function. Collaboration between counsel and the press as to information affecting the fairness of a criminal trial is not only subject to regulation, but is highly censurable and worthy of disciplinary measures. Since the judge did not fulfill his duty to protect Sheppard from the inherently prejudicial publicity which saturated the community and to control disruptive influences in the courtroom, we must reverse the denial of the habeas petition. The case is remanded to the district court with instructions to issue the writ and order that Sheppard be released from custody unless the state puts him to its charges again within a reasonable time. It was a bit of a long case, but I think it is important to look at both the factual scenario, how extreme these circumstances were, and what precisely it was that the court was responding to, and the limitations it perceived on the court's ability to control prejudicial publicity, period, and instead focusing on the way that the trial process itself needs to be the focus of the ultimate fairness inquiry here. And protecting the fairness of the trial may require that certain steps be taken in the face of prejudicial pretrial publicity. So that's the legal context that the defendants, Mr. Robinson, is operating against in the context of this motion. He is arguing that this standard has been met in this case, and that the prejudicial pretrial publicity is so bad that the court has authority to take steps, in fact, the duty to take steps to prevent him from that. The issue that they have is that the steps that the Sheppard court contemplated are the same steps that we've kind of heard Judge Graff talk about. They involve protecting the process, not shutting down the public conversation, taking steps to ensure that the jury is protected, that the members that are brought in for questioning, we have a broad selection, so we have the best possible chance of getting impartial jurors who haven't even heard anything about the case, which may seem unlikely, but I can just assure you there are plenty of people who have zero interest in criminal cases, zero interest in politics. They don't follow the story and are not interested in the details at all. These are all the remedies that the defense has to show. This isn't enough. This isn't enough. And so they have to translate that into an argument for why the live courtroom feed is contributing to this particular problem. And therefore, the court's duty to protect the trial process requires the court to eliminate that feed. So with that in mind, let's go ahead now and turn back to the defense motion so that we can see what some of this is based on. We have got an expert declaration here that the defense is presenting from Christine Ruva, PhD, in support of the motion to exclude cameras from the courtroom. So first off, who is she? She's a professor of psychology at the University of South Florida. She's a PhD. She focuses on the application of cognitive psychology to the legal system. For over 25 years, she's explored the effects of pretrial publicity on jurors' perceptions, emotions, memories, interpretation of trial evidence, deliberation behavior, and verdicts. My research also explores the effectiveness of remedies available to the court for reducing juror bias. I use both qualitative and quantitative methods, and she's been published many, many times. She's been asked to review evaluate and update the empirical research discussed in the final report by the Utah Judicial Council Study Committee on Technology, dated April 10th of 2012. This is the study I referred to that the judges did before they adopted the Utah rule that favors cameras in the courtroom. They looked at a lot of information about publicity and the threats that it poses and the possibility of mitigating those threats, weighed against the advantages that transparency of the courtroom process provides to the public, and ultimately decided transparency weighs in favor of having the cameras in the courtroom most of the time. So she is providing this declaration to ultimately criticize some of the research, some of the information that the court relied on when it made that determination. So a summary of the research here: decades of research by cognitive psychologists into the causes and impacts of bias, as well as individuals' ability to self-identify bias, establish several empirical findings that bear on the factors listed in the rule, the court camera favorable rule, in cases where pervasive and inflammatory pretrial publicity has occurred. First, pervasive and inflammatory pretrial publicity, especially live streaming of all proceedings, can lead to deep-seated bias. This bias is not merely an affinity for the victim or aversion to the defendant. It is cognitive, and as such, it fundamentally affects how jurors will process evidence during the trial and deliberate in the jury room. Second, these effects are heightened in cases involving notorious crimes such as alleged assassinations, terrorism, or violence against children. And in today's world of pervasive social media and live streaming of all proceedings, where information is ubiquitous, is pin-tailored to the fears and beliefs of the reader and the viewer, and may well be inaccurate, the impact of pretrial publicity is especially acute. Third, cognitive bias can be unconscious, making it difficult even for the most self-aware and well-intentioned potential juror to identify and self-report in response to general questions about bias. In fact, individuals with unconscious bias may be unduly confident in their ability to disregard pretrial publicity and judge impartially. Once seated, it can be difficult or impossible for jurors to set this bias aside. In short, scientific research into bias confirms what logic and good sense suggest. Merely questioning potential jurors about their exposure to and unconscious bias created by pervasive and inflammatory pretrial publicity will not be sufficient to eliminate such bias. While extended individual questioning of jurors to elicit bias in high publicity cases is certainly preferable to group questioning, the fact remains that unconscious bias caused by such publicity remains largely intractable. So a lot of these propositions are not particularly controversial in the modern era. We recognize that really since the 90s, our understanding of memory has expanded, has really transformed from what we used to think, which is that, oh, the memory is just like a little video camera that records everything in your head and plays it back to you anytime you're trying to recollect something. It's not at all what happens, and it's also influenced by what you perceive in the first place. And what you perceive in the first place is a factor of the attention that you give to things, and attention can be motivational. You pay attention to what you're interested in. You don't pay attention to what you're not interested in. And so this can be affected by other invisible processes that influence what you consider worthy of attention and what you don't. So this has been a real transformation in the understanding of memory and perception and how those things relate to bias. We think that we make decisions based on what our rational brain is doing, and the modern scientific view tends to favor more the idea that we make decisions at a subconscious level through non-rational parts of the brain, but then we use the rational part of the brain to offer explanations for why we have already reached that right decision, to justify that decision. And so that contributes to bias because people want to be right. People naturally, don't want to think that they're mistaken about things that seem very self-evident to them. And so once you've reached that decision, your logical processes are geared towards reinforcing it, looking for evidence to support it, ignoring evidence that tends to contradict it, coming up with explanation after explanation after explanation. There's a million reasons why I'm right and none why I'm wrong. These are the types of processes that reinforce bias as a cognitive process. So it's really not revolutionary to suggest that people can be exposed to information. They may be more or less attentive to, how important they think it is, and what about it may stick with them and why it may stick with them. And yet those processes are themselves kind of important in determining what's the likely effect that this information could have on your ability to be completely fair and impartial as a decision maker if, for example, you're confronted with conflicting information in the trial process. People just don't tend to be real aware of their own internal processes, don't tend to be super aware of all of their biases and so forth. So these are relatively uncontroversial from a contemporary standpoint. Now, that said, what's the source of the problem? Just because people getting information that can affect the judgments that they form that they may or may not even be aware of doesn't mean that the information they're getting from the live stream is part of that problem. So let's look at the argument that the live stream itself creates a problem. Media coverage of notorious crimes is different. The news media and today's social media cover crimes every day, and a steady drumbeat of even serious crimes makes most criminal coverage routine. But some crimes receive sensational coverage because they involve public figures, are especially heinous, extraordinarily violent, or threaten the community at large. And sensational coverage, by its sheer volume and by its content, has impacts that the everyday crime beat does not, especially when it is live streamed and then filtered through social media and other internet outlets. We're already now starting to get a little bit more distant from the live stream itself, and now bringing in, but it's not the live stream as filtered through the media of commentary that are available today. The volume of coverage in notorious cases can be overwhelming. Agreed. That's kind of the nature of it. That's what defines it as a high-profile case, the fact that lots of people are interested in it, and therefore there's a lot of publicity about it. Researchers have demonstrated that individuals exhibit a greater propensity to prejudge defendants when they are exposed to more publicity, both as a general conclusion and in response to specific thresholds. This effect has been demonstrated in both naturally occurring and controlled settings, confirming the validity of the proposition. So the more you know about the case, the more likely you are to prejudge it. Again, this is really not controversial. But this also, so far, isn't getting us out of the potential solution to this, which is find the jurors who have the least exposure to information possible. And then once you have found those jurors, once you've sorted out the ones, that are like following every single detail everywhere that they can find, then you focus on their ability to be open to new information, because that's really the challenge, right? Having an opinion based on information that you receive is about the most human process that there is. That's what we do. We get information, we process it, we form judgments about it. That's what enable us to do things like assess risks and perceive dangers and anticipate consequences and conduct our lives accordingly. So the fact that people receiving information are going to likely form an opinion about that information doesn't necessarily mean, however, that information is fixed and that that opinion is fixed and that it is unresponsive to new information. So this is a little bit of a nuance when it comes to my view of what bias really is. Like when I'm talking about bias, I'm assuming a fixed position. I'm assuming that we're kind of by definition talking about the type of judgment that is going to be resistant to new information. If you are in fact open to changing your opinion based on new information, then you are not biased. You are merely informed and have an opinion based on the information that you've reached. But if it's not fixed, you're not biased. That's how I use these terms and understand them. So just more about the extent of pretrial publicity affecting the likelihood of conviction. As potential jurors reported knowledge of a case increases, so does bias against the defendant. Collectively, these studies indicate that greater pretrial publicity exposure amplifies juror bias, increasing the likelihood of prejudicial verdicts. And this is supported by the ethical rules and the ABA's rules about pervasive publicity. Media coverage of notorious crimes is likely to be sensational and slanted against the defendant. So as a general proposition, yeah, a lot of what you hear is generally going to be in favor of the state narrative. And again, the Koberger case was kind of like the classic example of this. Just with the flood of the anonymous sourcing and the information that ultimately turned out to be false and so forth. Those errors that I can recall, I can't recall a single instance where it cut in favor of the defense. These were always pro-prosecution narratives. That seems to be much less the case with Tyler Robinson. It's been a bit remarkable to see that his situation seems to be quite an exception to the norm, where an extensive amount of the conversation and commentary and so forth through at least these alternative channels that she's particularly interested in, social media and the internet and so forth, is not guilt presumptive whatsoever. So in many ways, he's got like a much greater volume of potentially helpful publicity that is out there that is not automatically favorable to the state narrative. So not really clear that this particular case falls within this general assessment that she's offering, that it tends to be bad for the defendant. The rise of social media has exponentially increased the quantity and quality of information regarding notorious crimes available to the public. And social media not only is pervasive, it also spreads information. Now, I'm going to pause right here to notice now, once again, how further we've shifted, right? We started with pretrial publicity is the problem. Then we shifted to pretrial. We shifted to the live stream. The live stream is the problem. That got shifted to the live stream filtered through social media is the problem. And now we've gotten to social media is the problem because it feeds misinformation. We are getting more and more and more distant from the live stream itself and the role that it has within this ecosystem, which is to be the source of accurate information. The live feed is what is happening in the courtroom. It is the most reliable source of information about the court proceeding. It's more reliable than the transcript because you get to see what happens and you get to see when there's like pauses between, and you can see the tone in which things are said and the expressions people have when they say things. You get to see all that stuff that you don't get from reading a transcript. It's obviously way more valuable than just reading somebody's account of what happens in the courtroom. So we seem to be getting ever more distant from the subject of this request, the cameras in the courtroom, the live streaming the court hearing. We're getting further and further from that to try to justify why that's a problem. We're having to conflate it with publicity as a whole and social media commentary. And I think part of the challenge that the defense faces here is the very real possibility that the court live stream acts as an antidote to some of the problems that she's observing in particularly the social media, but also in the conventional media, is not at all immune from reporting false information and things like that. She talks about the Boston Marathon bombing. Oh, now I got to tell you, this is a woman after my own heart to bring this one up, because this is a massive indictment of the sleuthing mentality, the idea that just by being on the internet and looking at things that are available on the internet, that people who are completely unrelated to the investigation are going to be able to solve it in ways that the investigators will not. It takes a massive lack of humility to assume that that type of attitude. And the Boston Marathon bomber case was a very good example of that that humility, that lack of humility, being really highly illustrated. There's a very substantial argument to be made that Reddit's involvement caused the death of one of the victims of the Boston Marathon bombers, the security guard who was ambushed by the Tsarnaev brothers after there had been all of this sleuthing, and police ultimately released some photographs of the suspect to try to tamp down on the suspicions that Redditors primarily at this time were throwing out about who the bomber was. So lots of misinformation in the course of the Boston Marathon bombing. I agree completely that that particular episode is one that should not be forgotten. Many lessons learned from that whole experience that we would do well to maintain sight of today. In short, the volume and nature of traditional and social media coverage of notorious crimes greatly increases the risk that prospective jurors for these cases may already have formed beliefs about the case, which can lead to biased decision making. Of course, again, doesn't automatically. It depends on how open and receptive they are to new information, but it certainly can predispose them to thinking a certain way. And so research also shows that pretrial publicity that generates emotions such as anger and disgust has a significant impact on judgments, more so than purely factual publicity. And notorious crimes subject to exhaustive reporting can generate substantial emotional responses. Yes, emotions do tend to affect cognition and decision-making and memory and so forth. So going on to this, a lot of detail about this and just the role of emotionalism in the decision-making process. And finally, the modality, visual, auditory, or text of pretrial publicity and case information matters and has different effects on juror bias, emotions, and memory. So this study conducted a juror simulation experiment to compare the relative effects of television and print media on juror bias in a highly publicized child sexual abuse case. Participants randomly assigned to receive pretrial publicity through newspaper articles, televised excerpts of testimony, both media types or control condition. The study found that exposure to television coverage produced significantly stronger emotional reactions, greater belief in the credibility of victims' testimony, higher perceptions of the defendant's guilt, and harsher sentencing recommendations than exposure to print media alone. Combined exposure to both television and print media had the most pronounced biasing effect. Importantly, despite these differences, participants across all conditions reported similar confidence in their ability to remain impartial. Everybody always thinks, nobody's going to think, oh, I can't be fair. Everybody always thinks they can be fair. So interesting argument that's being made here. I am not familiar with this study. I am a little curious about the study design, though, because one of the questions I would have about this case is how guilty was the defendant and how evident was his guilt in the trial process? Because if a juror, for example, is watching the testimony, watching the process itself, and that causes the juror to form a stronger impression of guilt than just reading newspaper articles about it, If the defendant is in fact guilty, then it kind of seems like the newspaper or the television testimony is doing a better job at aligning the viewer with the reality of the situation as is being litigated in court. If the defendant is really super guilty and it's obvious and everybody who's watching can see that for themselves, then you would expect the people that are watching to have stronger opinions about that than the people who are just reading about it in the newspaper. I would offer Depp v. Heard as kind of the preeminent example of this phenomenon, where folks who watched the trial, every single minute of that trial, of whom I am one of many, like millions of people watched this trial. It was absolutely crazy. Had almost uniformly the same opinion about what they were watching. And it was distinctly different from much of the coverage that was being presented in the conventional media on, commentary and news reporting and things like that. So being able to see it for yourself arguably puts you in a better position to have the right opinion. That's what I'd like to see, how and if that was accounted for in the study, or if it just assumed that any conclusion being reached is bad, therefore a stronger conclusion is worse than a weaker conclusion. I would contest that formulation of the situation. If it really strongly pushes your opinion in one direction and that opinion happens to be right, then it seems like that might actually be a good thing. Then another study examined the prejudicial impact of visual versus auditory evidence on mock juror emotion and verdict decisions in a murder case. Visual evidence conditions included graphic images, neutral images, or no images. Auditory evidence consisted of a 911 call recording. Jury instructions were either standard or revised to warn against emotional bias. Results indicated that graphic visual evidence significantly increased conviction rates compared to neutral or no images, whereas auditory evidence had no significant effect on verdicts or emotional responses. Again, I'd like to see the structure of this study. How did they set it up? Given this evidence, how guilty was the defendant? So then we have this conclusion here. Applied to trial recordings, when courts permit video that includes still frames or inserts of graphic visuals, such as crime scene images displayed during recorded proceedings or streamed hearings, those visuals can create distinctive, durable memory traces that affect perceived credibility and culpability, thereby biasing adjudicative assessments, even if jurors believe they can remain impartial. It is true that what people see with their own eyes tends to be very influential. What I'm not quite sure yet is that this is necessarily a problem. So we see some other studies, explanation why visual is more than less and so forth. Collectively now, collectively, these studies on modality effective information presentation demonstrate that visual and multimedia evidence pose a substantially greater risk of prejudicing jurors than auditory evidence or print formats. Visual formats, especially graphic images, video recreations, and televised coverage, amplify emotional responses, increase perceptions of guilt, and alter liability assessments, while auditory evidence exerts minimal biasing effect. Moreover, jurors often fail to recognize their susceptibility to these influences, and judicial instructions have proven largely ineffective in mitigating such biases. These findings strongly support the need for careful judicial scrutiny of highly visual or emotionally charged evidence and extensive pretrial publicity to preserve the defendant's constitutional right to a fair trial. So this was a rather long and somewhat meandering argument through a lot of commentary about the effects of things that are not the court live stream, conflating those with the effects of the court live stream, And then from my perspective, arguing that the opinions formed by watching the live stream are more biased than the ones not informed by that experience, and that bias is necessarily like not in alignment with the outcome, right? That the bias is bad. It's inconsistent with the conclusion, I guess, that you should reach in light of the evidence. So from my perspective, not really the strongest argument here that the live stream itself is the problem. Totally on board with the defense here that pretrial publicity can pose huge problems for the jury pool. This is not revolutionary. This is not a surprise. But it does not provide me with an awful lot of reassurance that the live stream itself is the problem and not in fact the cure to that. Because let's just anticipate, hypothetically, the order is granted, cameras are removed from the courtroom, we no longer get to watch what happens in the courtroom. That does nothing to eliminate or minimize the other things that she is acknowledging are big contributors to the problem, if not like the main contributors to the problem anyway, which is the social media and internet commentary. That's what they don't like. They don't like us. They don't like us talking about the case. That's going to continue to happen. And so those problems are going to continue to persist. And so if we don't have the courtroom camera available, do we think that the remaining social media conversation is going to be more or less grounded in factual reality about the court proceeding? Do we think that is going to favor or disfavor the growth of misinformation and disinformation in the case? That's the problem with this conflation that I see. I am very sympathetic to the argument that pretrial publicity is problematic. Part of the reason why it tends to be such an issue in criminal cases is because what happens, just based on the timing, is that the prosecutor, there's a crime, it gets a lot of attention, people are super interested in it, people want assurance that the prosecution is taking the right steps, they've got the right person, everybody else is safe, this egregious harm is going to be rectified, and that they can now kind of put it out of their minds. They can rest assured that it's in the right hands and they've got the right person, and so on and so forth. So the attention that cases get in that situation is going to be focused on the prosecution and on what they have to say, particularly when they have made this decision. We've identified a suspect, we're conducting an arrest, we're filing criminal charges. Here's why. You routinely get that initial explanation, and then that's it. That's it. You don't get a lot of responses from the defense a lot of the time. You hear the prosecution, and then that's like the last thing you hear until the court proceeding moves further through the process. So to me, this seems a little bit just more inherent in the psychology, the social psychology of big high profile incidents like this. The fact that, yeah, it's going to scare people and it's going to anger people, and they're going to want to know, they're going to want some assurance that the legal process is taking care of those considerations so they can put those feelings aside. And that is normal. That is never going to go away. People are always going to want that. And the idea of oh, just trust the government to charge the right person and don't worry about the reason why they're doing what they're doing until we get to the trial, which might be years down the road, by the way. Just defer your concerns until we get to that point. This just isn't realistic, nor is it something that I think, most people actually want. I don't think most of us really trust the government enough to be giving them that kind of leeway and that kind of hands off. So I wanted to give you that as a little bit of a basis of what the defense is arguing here. We've also got a second expert from Dr. Edelman, very similar, a lot of overlap, has apparently done a survey in Utah County, has gotten some information about the jury pool itself in Utah County. He has also provided here a summary of his opinions that he intends to present. We saw Dr. Edelman testify in Brian Koberger's case, and I understand he was also a witness for Corey Richens. So he is pretty well known at this point. And I find his information very fascinating, very, very credible, very plausible. In this particular case, what he talks about is how the modern news environment is different from the legacy media. The internet is everywhere. We're constantly exposed to it. And when the algorithm drives what we're exposed to, it's a lot more difficult to just not be exposed to information that is catching attention by people who are similar to us within our geographic region and so forth. So in legacy media, you had to go and buy the newspaper. You had to turn on the TV. In the modern era, all you have to do is open up Instagram and the algorithm is deciding for you what are you going to see. And it's making that decision based on a whole complicated bunch of factors. But a lot of those are going to favor if you have overlap with politics, you have overlap with interest in the news, you have overlap with the local community, just all increasing the likelihood that this information is going to be fed to you, whether you are looking for it or not. And based on that, he has reached conclusions that in high profile cases, it can be much, much harder to avoid the publicity for people in Utah County who aren't really interested in the case to nevertheless not remain kind of blank slates about it. And so it becomes more pervasive in light of the effect on decision making, the potential to bias the jury's decision making process. These are considerations that are important. And again, I don't disagree. I don't disagree with any of this, but I don't see that it justifies the conflation of the court's feed, the live courtroom feed, with the other things that they're talking about here, like the commentary and the citizen journalism and the false information and all of those types of things that tend to be so problematic in criminal cases. So this video has gone on a little bit, but I think it's just important to get a sense of what is really at stake here, and why this is in fact such an important issue. I don't in any way, by kind of pointing out some of these critiques I have of the defendant's reasoning and his argument, I don't in any way tend to suggest that means this is not an important issue and that it isn't actually something very significant in the criminal justice system in the modern world. The fundamental problem that the defense is really highlighting here, in my view, is that the Constitution provides two guarantees: that we, the public, will have the right to watch our government at work when it goes into a courtroom and tries to subject a citizen to deprivations of liberty, property, life even, and so forth. That guarantee has the potential to conflict with the guarantee that every criminal defendant is entitled to a fair trial by an unbiased jury. Because what this motion and this context seems to be highlighting is the possibility that in a high-profile case, it's simply not possible to have both of these things. They simply cannot coexist. That the fictions that we have historically relied on to assure ourselves that they can, that, oh, we can just ask jurors if they can be fair, you know, and that's going to solve it. These aren't actually gonna solve anything, and that we have the scientific knowledge and the kind of basis of understanding of decision making to recognize that's simply not how it works. And so, to the extent that there is a conflict, what's going to change? What's got to change? If, as Mr. Edelman is suggesting, as many as 99, somewhere between 99 and 100% of the prospective jurors in Utah County are going to be exposed to pretrial publicity about this case, that tends to undermine the suggestion that you can fix the problem by bringing in a whole bunch of, extra large jury panel, because the coverage is so extensive, the reach of it's completely permeated the community. There aren't untainted jurors to be able to call in. The idea that we can just ask them, what have you seen? How has it affected you? Can you still be fair? We kind of know that, one, a lot of this stuff is people are blind to it. We don't even know. We don't know what we don't know about our own cognitive processes. We are also biased in our own favor. We give ourselves the halo effect. We assume that our motivations are pure and our intentions are good, and that we will dutifully sort these things out. And because we're good people, you know, we're certainly not going to be biased or anything like that. Just reject that idea, and that blinds us to those tendencies in our own characters. The defense is highlighting that these traditional tools might have worked in an era where you can just sort out who buys the newspaper and who doesn't, and kind of select yourself a jury pool that is already less informed and therefore less biased about the case. In this day and age, where the information reach has just gotten a lot further, that's really not going to be a viable solution. So this is, I recognize, a very real problem, a very real consideration that defense attorneys have, and I understand completely why they, as defense lawyers, are concerned about the prospect of the jury pool that they're going to be facing. Should this case reach the point where it is in fact proceeding to a jury trial. So I have complete sympathy for it. I am just not really sure that I buy this explanation that those problems are attributable to the live stream coverage, and not the contrary position that the live stream coverage, by providing a factual basis of information, is not in fact the palliative for some of these problems that are going to increase the risk of bias and bad decision making and misinformation and all of that type of thing. So that's what's on the docket for Friday. I think it's going to be interesting hearing a lot of this psychological decision-making bias type of information. It was fascinating when we heard about it in the Koberger's case. I'm expecting more of that to come tomorrow. But I think the weak link is going to be this connection between a lot of pretrial publicity and conflating the effects of that to specifically the camera in the courtroom. Might be a bit of a challenge. So, guys, I'm going to be there for the hearing, live streaming, you know it. So I plan to have that set up. Usually get started, 15 minutes or so before the hearing is scheduled to start, so that we can kind of recap where we are. But obviously, this took a little bit longer than that to give us a little bit of the background. So, with that, I hope you are well informed and well prepared for tomorrow's hearing. Not in a biased way, not in a way that's going to close you off to any new information that you may hear tomorrow. I am certainly going to do my best to be open to whatever information the parties should choose to present. But that is my initial impression based on what I've seen in this case so far, and just the general laws, background, principles, etc., that apply to the conflict between the public's interest in seeing what's going on inside the courtroom and the defendant's interest in getting a jury that is objective as possible. So, guys, thank you again for joining me. Look forward to the hearing, and I will see you guys then.